If you've been appointed as personal representative in a probate, it's important to understand what powers you have in this position. Hi, I'm Paul Groh, Director of Estates Administration at the Law Offices of Daniel A. Hunt. In this video, I'm going to explain the difference between full and limited authority under the Independent Administration of Estates Act, and how to deal with any real property included in the estate. First, what's the Independent Administration of Estates Act, also known as IAEA? Well, passed in 1987, the IAEA outlines actions a personal representative can take to administer an estate without court supervision. Authority to administer the estate under the IAEA can be granted by the decedent's will or the court upon petition by the personal representative. Often, when the personal representative files their opening petition at the beginning of the probate, their petition includes a request for full authority under the IAEA. However, you can file a petition requesting these powers at any time during the probate process. The court may deny IAEA powers if an interested party objects to the petition with good cause, or the decedent created a will that specifically denies the executor these powers. If the petition is denied, the court may grant the personal representative limited authority under the IAEA. Full authority granted under the IAEA rules allows you as the personal representative to do any of the following real estate related tasks without court supervision once you give a proposed notice of the action to the heirs or beneficiaries. You may sell or exchange real property, grant an option to purchase real property, act on claims against the estate, pay taxes, assessments, and expenses incurred in the administration of the estate. If the court only grants you limited authority, all of the actions listed above require court supervision and approval. Court approval of the action may also be required if you or your attorney are the principal performing any of these tasks. For example, if you, as the personal representative, are the buyer purchasing the decedent's home, this action may require court approval. Even when granted full authority under the IAEA, a personal representative does not have unlimited power. You still need to seek permission to sell real property with a notice of proposed action. This notice should be sent to any person or entity who has an interest in the proposed sale or may be affected by it. The exception would be if that person had waived their right to this notice in writing. The notice should be sent to the following categories of people: everyone named in the decedent's will, each known heir if the decedent died intestate, that is, without a will, and any other interested person requesting notice, like creditors or beneficiaries of a trust, and the Attorney General if any portion of the property is to go to the state. The notice of proposed action must include all of the following information: your name and mailing address, the name and telephone of the person to contact for additional information, a reasonably specific description of the action to be taken, including a description of the property and the terms of the sale, exchange, or granting of an option to purchase property, and the date on or after which the proposed action will occur. At least 15 days before the date of the proposed action, the notice of proposed action must be mailed or personally delivered to everyone entitled to receive it. If you are not sure how to contact any of these individuals, mail the notice to their last known address. Send the notices via first-class mail. While a personal representative who has been granted full authority to administer the estate under the IAEA is not required to do so, there are advantages to using these powers. Real estate sales under the IAEA are faster than court-supervised sales, which allows you to pay estate expenses as they occur. If you need help seeking court authority under the IAEA or any other aspect of estate administration, feel free to contact our office. We hope this video has been helpful, and if you have any questions about estate administration, feel free to contact the law offices of Daniel Hunt using the information listed below. Thanks.